Hi, I am Dr.Souvik Chatterji, National Law University, Jodhpur. I am the assistant professor there. This particular module in the context of competition law is titled Duties, Powers and Functions of DG, CCI and COMPAT in India. Meaning it's the Director General, the Competition Commission of India and the Competition Appellate Tribunal in India. Before I go into the overall the duties, powers of the Director General, one small thing has to be explained in the context of India, that India actually had started with a competition law that was in existence in the late 1960s. India was under a command and control regime at that time. So the Monopolies and Restrictive Trade Practices Act 1969 was enacted, and at that time it was understood that any form of dominance was considered to be per se bad. So for those reasons, those so-called undertakings who crossed 20% of market shares, they themselves used to be considered injurious to the economy as such. So the MRTP Commission at that point of time used to look on to two things. One included the restrictive trade practices, which included all the different forms of collusions, cartelizations, abuse of dominance, etc. The other form included the unfair trade practices. Generally the domain relating to unfair trade practices had been taken up by the Consumer Protection Forum, that is under the Consumer Protection Act of 1986. Now in 2002, later on, a new act had been passed in the Indian context, understanding that the MRTPC, that means the Monopolies Restricted Trade Practices Commission, they actually did not have the amount of teeth that they should have, with which the so-called perpetrators of the different forms of cartelization and collusion, they could have basically faced the deterrent effect. Actually the MRTPC only had the so-called power to seize and desist from, ask the parties to cease and desist from their existing conduct. So now came the question of a new respective act which was more powerful, more advanced, and that had been passed in 2007. There were two so-called writs being filed, and after that in 2007 the Competition Act actually came into force in India, and the Competition Commission of India was being created to look after all the different forms of investigation and all the other activities, and the Competition Appellate Tribunal, that was the so-called tribunal which had been created to actually look into the different forms of adjudication of disputes. Well, in the context of the DG, the Director General leads the investigation in the context of every form of investigations carried out by the Competition Commission of India. Director General in India refers to the DG appointed under subsection 1 of section 16 of the Competition Act and includes any additional, any joint, any deputy or any assistant Director General appointed under the section. The Director General is expected by the Commission to assist the Commission in investigating into any contravention of the provisions of the Competition Act whenever required, or investigated into contravention of any rules or regulations thereunder. The Director General have all the powers conferred upon the Commission under subsection 2 of section 36. Now in the context of section 2G, they basically had also defined who basically includes the Director General in the Indian context as such. Where the Competition Commission of India upon private complaint or suo motu, that means on its own accord, considers that a prima facie case exists, it shall ask the Director General to investigate into the matter. In respect of investigations whether carried out suo motu or complaint filed by the aggrieved party, DG submits an investigation report to the CCI within a specific time period. CCI sends the DG report to both the parties for inviting their comments and objections. After that, after further hearing, the Competition Commission of India then passes appropriate orders. In the context of the Competition Act 2002, the Competition Commission of India has very strong powers. In case they want to pass any respective order relating to paying fines and penalties. Penalties include almost 10% of annual turnover for the previous 3 years. Section 26 clause 1 of the Competition Act 2002 as amended by the Competition Amendment Act 2007 focuses in the context of the procedure that is being taken up on the part of the DG once the complaint or the suo motu jurisdiction is being exercised. Now, in this context, there are a number of success stories of the Competition Commission of India, and in the Indian context it's better to let everyone know in the context of what CCI had done from 2008 onwards. This is 2014. In the last 7 years there had been a plethora of judgments that had been passed by Competition Appellate Tribunal and a number of investigations that were being carried out by the Competition Commission of India, and in those cases they actually had given landmark fines against big corporations. In June 2012, Competition Commission of India imposed a fine of rupees 63 billion against 11 cement companies for cartelization. CCI investigation revealed that the cement companies, they made secret pacts and had illegal profits. In January 2013, CCI also made successful investigation against DLF in abuse of dominant case. A brief information in this context requires mention. As far as DLF is concerned, DLF basically consists of a very big group of builders, and they are very successful in respect of entering into agreements and contracts with respect to a lot of private persons who wants to buy flats and apartments in different parts of the country. Now, in the case of DLF, what they had done was they actually created one-sided contracts, and the contracts were such that those who basically wanted to buy the flats, the builder did not give any complete ownership of open spaces within the residential project of the area that were being sold. Not just that, the buyer in that case did not actually given any form of compensation or exemption in case the buyers actually made any defaults. All payments made by the buyers, they were supposed to be based on construction milestones and not on demand. The builder were not given any form of other so-called restrictions in the context of the form of agreements that they actually filed. What essentially happened was that in the context of the buildings that were being built in Gurgaon, after building the smaller units, DLF went forward, and from a 20 to 25 storied building they converted them into 30-40 storied building, and all of a sudden when the number of floors were increased, as far as the buyers were concerned, they were at their back foot. They did not have any choice that were left. So many of these buyers are those so-called buyers who were basically staying in so-called apartments which were rented as such, and they were paying rents to their landlords for indefinite period of time. So when they had made their earnest deposit paid, they never wanted to wait in the context of how long DLF would have taken in terms of completing the so-called apartments. CCI had a very important role to play in this particular context, and when the question relating to DLF's so-called exercise in the context of abuse of dominance was taken up, the first so-called prerequisite that was there on the part of the CCI was to prove that DLF had been dominant. So what CCI had done was they basically looked into the relevant product market and relevant geographic market. The geographic market included the high-rise buildings in Gurgaon, and the product market included the so-called flats and apartments being sold at the so-called place in Gurgaon. So after proving dominance, abuse of dominance was also being established, and thereafter DLF had been fined very heavily on the part of the Competition Commission of India. CCI has a very important role to play in the context of addressing cartels, abuse of dominance and combinations. The Competition Commission basically comprises of a chairperson and 6 members. Ashok Chawla is the current chairperson of the Competition Commission of India. Now, the MRTP Act 69, as being mentioned earlier, only required the enterprises to cease and desist from the anti-competitive activities, as opposed to the question of the Competition Commission of India, which can not only stop their respective parties from continuing with the anti-competitive activities and abuse of dominance, but they are also being asked to actually pay fines, and which are of landmark nature. One of the important duties of Competition Commission of India includes detection and prevention of cartels. A cartel is defined in section 2 clause C of the Competition Act of 2002, and the definition says it includes associations of producers, sellers, distributors, traders or service providers who agreed to limit or control or attempt to control the production, distribution, sale or price of trade in goods or provision of services. Section 3 of the Act lays down a general prohibition against enterprises or association of enterprises and persons entering into an agreement which either can be horizontal or can be vertical, which causes or is likely to cause an appreciable adverse effect on competition. Now, in this context, it has to be explained that the Indian yardstick that has been put forward on the part of the CCI includes the appreciable adverse effect on competition. It is as opposed to the question of per se illegality and rule of reason that is being taken up by other jurisdictions. Now, as far as appreciable adverse effect on competition is concerned, it's a so-called yardstick which is higher than that of rule of reason but lower than that of per se illegal. Now, an inquiry into a violation of the Act can be triggered upon the receipt of a complaint by the Commission or upon its own motion, which is also called suo motu action. If the Commission is convinced that a prima facie case exists, it proceeds to direct the Director General to commence an investigation, the DG. We have already discussed about what are the so-called functions and duties of the Director General. When the DG completes the investigation, he submits a report to the Commission, which then decides what action is to be taken. Section 46 of the Competition Act 2002, as amended by the Competition Amendment Act 2007, provides for leniency as well. As I have explained a number of times that leniency or amnesty is a so-called incentive that is being given to a cartelist who, after entering into the cartel, fears the fact that if the competition agency is successful to prove the cartel, the so-called cartelist can be very severely fined. Now, in the context of this incentive, it has to be said that during British regime also there was a system of approvers, and the approvers were given incentives so that if they would have given evidence as against the freedom fighters, their existing so-called liability before the court of law could be so-called exempted. Now, in this context, in the Indian context, it's mentioned that by the power vested in it through the provision, along with the power to make rules and regulations, Government of India can also bring out lesser penalty in this context. Now, in fact, the lesser penalty regulations were being passed in 2009 in the context of cartelization and anti-competitive agreements. Section 46 states as follows: the Commission may, if it is satisfied that any producer, seller, distributor, trader or service provider included in any cartel which is alleged to have violated Section 3, if they had made a full and true disclosure in respect of the alleged violations, and such disclosure is vital, it can impose upon the producer, seller, distributor or trader or service provider a lesser penalty as may deem fit. Only the thing which is absent in the Indian context is that whether the so-called leniency is also being extended to the second so-called cartelist. The first informant is the only informant who is being granted leniency in United States jurisdiction and many of the other advanced antitrust jurisdictions. Abuse of dominance is the other infringement of law which the Competition Commission of India addresses under Section 4 of the Competition Act 2002. DLF case is the most landmark case as being mentioned in India in the context of success stories of Competition Commission of India in respect of addressing abuse of dominance. The conditions that CCI found abusive in DLF's Vidya-mitra project agreement includes the following: unilateral changes, that means changes as proposed or thought about by DLF only, they could be made by the builder without the buyer's consent. That was being put forward in the Vidya-mitra Owners Association versus DLF Limited. This was case number 19 of 2010. DLF case basically speaks in the context of the success stories of the Competition Commission of India in handling abuse of dominance cases. Now, DLF unilaterally they decided to increase the size of the buildings from 19 floors to 29. The builder enjoyed the unilateral right to increase or decrease the super area, that is the super build-up area, at the sole discretion without consulting the allottees, who nevertheless were bound to pay the additional amounts or accept a reduction in the area. It was absolutely unfair on the part of the buyers themselves, because in majority of the urbanized areas, buyers themselves don't have so-called choices when they actually pay the earnest deposit, the money that had already gone does not allow them to actually go forward and enter into a deal with other so-called buyers or builders. Well, allottees had no exit option except when the builder failed to deliver the possession within the agreed time. But even in those cases, they got refunds without interest, and that too only after the apartment was sold, meaning that if DLF failed to provide, let's say, a respective allottee a so-called flat by 2010 under the agreement, then the allottee had to wait from 2010 to 2017 for the next 7 years or 10 years till DLF had completed all the so-called apartments and thereafter built them and got their profits and could pay them back. So a buyer who was already staying in a rented house did not have the scope of getting the earnest deposit back and negotiate with any other builder till all the flats were sold in the said complex in Gurgaon. Punitive penalties that were imposed, in this case on the part of DLF. DLF took crores of rupees from the allottees. Even before the first brick was laid, Competition Commission of India found the 16 conditions all being unfair and abusive. It has also been mentioned in the book of Dr.Souvik Chatterji, which is also presented in a respective article. The title being "The DLF Case is a Landmark Decision Regarding Abuse of Dominance and Relevant Market in India." It's published in Competition Law Insight on 29th April 2014. Opinion in this context is being created by this UK journal. Well, the next important part in the context of the powers and duties of the Competition Commission of India includes regulating combinations. India basically has a mandatory merger notification regime, meaning that in the Indian context there is no choice being given on the parties, that means the so-called merging entities, whether they want to come before the Competition Commission of India to let them know that they have merged together and thereafter ask them to get the merger reviewed. But the thing is that it's mandatory on them in case they cross the threshold. India had actually created asset threshold and also turnover threshold. Many countries in the world as such also have voluntary merger notification regime. For example, New Zealand and also Ireland, they are some of the so-called jurisdictions who actually have voluntary merger notification regime. The CCI can regulate combinations that cross the threshold limit created by the Competition Act 2002 as amended by the Competition Amendment Act of 2007. Only if the notification is made mandatory. If it was voluntary, many companies could have escaped the review of the CCI in spite of crossing the threshold limit. At the same time, the CCI does not want any of these big companies to gain their amount of market share from where they can control the market and abuse their dominance. Neither the CCI wants the giant companies in entering into combinations and get involved in predatory pricing and driving out the rest of the companies from the market. Interesting enough, in this context it has to be understood by market power, what is supposed to be explained or what is supposed to be meant is that the so-called parties, they can actually act independent of all the different market forces, meaning that even if the so-called the standard of the goods or the services, they are deteriorated or the prices are increased, the consumers still flock down in respect of the same so-called providers, whether service providers or the producers of the so-called goods. Now, thresholds. India, as being mentioned, has mandatory notification regime. India created thresholds in the context of 1,500 crores is the threshold in the context of assets, and rupees 3,500 crores is the threshold in the context of turnovers. According to that regulation, the value of assets include the brand value, the goodwill, the value of intellectual property, but definitely not the depreciation. Amendment of Schedule 1 of the Combination of Regulations 2013 grossly had highlighted, as a matter of fact, the question relating to the thresholds as such. Well, in the context of these two thresholds, it has to be understood that India did not look for any form of market share being considered to be one of the threshold, although the question related to market share has been kept as one of the factors that are supposed to be determined under section 20 to find out whether the so-called merger had been pro-competitive or anti-competitive. Now, the third and the most important body in the context of competition regulation includes the Competition Appellate Tribunal. The Competition Appellate Tribunal is the adjudicatory body which hears appeals from order passed by the CCI. The appellate tribunal is empowered for the purpose of hearing appeals and disposing of appeals against the directions issued by the Competition Commission of India or directions given by the Competition Commission of India under section 2 clause 6 of section 26 and section 27. The central government has set up the appellate tribunal on 15th May 2009. It had happened around 6 to 7 months later of creating the Competition Commission of India. As a matter of fact, when the writs were being filed in between 2002 to 2007, one of the contentions was that the administrative functions and the investigating functions were already being performed by the Competition Commission of India, and the same CCI was supposed to also look into the adjudicatory powers. Under our rules leading to separation of powers, these are not possible. For those reasons, under the 2007 Act, that means Competition Act 2002 as amended by the Competition Act Amendment Act 2007, the Competition Appellate Tribunal was created separately. So CCI started looking into investigations, and Competition Appellate Tribunal had both original and also appellate jurisdiction. The central government set up the Appellate Tribunal on 15th May 2009, having its headquarters at New Delhi. Honorable Justice Arijit Pasayat, the former Honorable Supreme Court Judge, had been appointed as the first chairperson of the Appellate Tribunal. As far as the composition of the Competition Appellate Tribunal is concerned, in addition to the chairperson, there are 2 members to be appointed by the central government. Section 53A of the Competition Act 2002 as amended by the Competition Amendment Act 2007 speaks in the context of the Competition Appellate Tribunal. The chairperson of the Appellate Tribunal, they require the following qualifications. He has to be the judge of the Supreme Court or the Chief Justice of a High Court. A member of the Appellate Tribunal should have special knowledge and professional experience of not less than 25 years in competition matters, including competition law and policy, international trade, economics, business, commerce, law, finance, accountancy, management, industry, public affairs, administration, or any other matter which in the opinion of the central government may be useful in the Appellate Tribunal. As far as appeals are concerned, every appeal shall be filed within a period of 60 days from the date on which a copy of the direction or decision or order made by the Competition Commission of India is received, and it shall be in the prescribed form and be accompanied by the prescribed fees. The Competition Appellate Tribunal is bound by procedure laid down by Civil Procedure Code 1908, is empowered to summon and enforce attendance of any person, examine him on oath, require discovery and production of documents, receiving evidence on affidavit, issue commission for examining of witnesses, dismiss a representation on default under the Competition Act 2002. It is interesting to note, in the Indian context, the Competition Act has not created any criminal sanctions. So majority of the cases where administrative penalties or fines and compensation are being asked to be paid on the part of the alleged parties who are proved to have committed anti-competitive agreements, there the so-called proof is through preponderance of probability. Although the powers are similar to civil court or original jurisdiction, the technical details are not expected in the tribunal, and strict adherence to Indian Evidence Act is also not required. Section 53 clause O of the Competition Act 2002 as amended by the Competition Amendment Act 2007, they speak about that. In the context of now summing up the conclusion, it can be said that the DG's office, the Competition Commission of India, and the Competition Appellate Tribunal's office had started working from 2008 onwards. So all these bodies are very, very new. So what is understandable that in the Indian context there are so-called provisions within the Competition Act 2007 which has not been exercised to a single instance till now. It does not speak in the context of non-success or failure on the part of the so-called bodies, that is DG and the CCI and the Competition Appellate Tribunal. What it says is that as the bodies are very new, it is not expected that before 25 years or 30 years there will be plethora of case judgments, and the so-called judgments will act as law by themselves. So it will take time to gather expertise to deal with the complicated cases. Already the Competition Commission of India had showed huge success in investigating and proving the cement cartels and the abuse of dominance in the context of the DLF case. more number of penalties and better utilization of the corporate leniency policies, they can create more confidence on the Competition Commission of India and the other bodies concerned. In this context, what India is supposed to look into, in case where there are no case judgments in the Indian perspective, are the case judgments of United States, European Union, South Africa, Brazil and the other jurisdictions where the law is already quite in place for a long period of time. As far as books are concerned, in the context of competition law in India, the main books which are of eminence includes Vinod Dhal's book. It's called Competition Law Today, Concepts, Issues and the Law in Practice. The first edition was published by Oxford University Press in 2007. The second book which is of eminence includes T. Ramappa's book titled Competition Law in India, Policy, Issues and Developments. The first edition was published by Oxford Press in 2006. The third book, which is also important, includes Competition Law in India and Cartels in India and United States, published by Allahabad Law Agency. Dr.Souvik Chatterji is the author of the book. It was published in 2014 and the first edition speaks in the context of both cartelization and also the powers of the Competition Commission in India. Before ending the entire so-called presentation, a quick summary in respect of whatever had been discussed. Now, the powers, duties of the Director General, the powers, duties of the Competition Commission of India and the Competition Appellate Tribunal had been discussed in the overall chapter. Important enough, it has been seen that in the Indian context, India previously did not have the extraterritorial jurisdiction. That means the MRTPC did not have the extraterritorial jurisdiction. The Competition Commission of India under section 16, it has the extraterritorial jurisdiction and the FX doctrine is put to use in the Indian context. So basically the Competition Commission of India, the DG, looks into three aspects. One includes the anti-competitive agreements, the second includes the abuse of dominance, and thirdly they basically look into review of combinations. And the Competition Appellate Tribunal is the adjudicatory body which both has original jurisdiction, at the same time the appellate jurisdiction to look into disputes. India's law is very new. The more the number of cases will come and the more the cases are going to be decided, that will generally make the so-called regime more mature. Thanks a lot.